Hello, everybody. If we could start, it's 2 minutes after starting. I hope that yes. So I will speak Czech because we have a translation, and I start this very nice conference, and I hope that you're looking as me. And thank you very much, our technical advisors and our staff, which help us with organize this conference. So, and now I will start in Czech. Vážené dámy, vážení pánové, jsem velmi ráda, že jsme si našli čas, aby jsme se účastnili nebo případně zpětně podívali na konferenci politické skupiny The Left v Evropském parlamentu s názvem Jak bezpečná je AI. Red Lines chránící naše základní práva, kterou můžeme poslouchat v češtině, angličtině, francouzštině a němčině. Nehodlám na začátku mluvit příliš dlouho, protože velmi silně věřím, že nejvíc prostoru by měli dostávat zejména u takto citlivých problematik primárně experti. Jsem tedy ráda, že vás v tomto směru nesklamu, když vám řeknu, že si budete moci vyslechnout odborníky z tak vynikajících organizací, jako je EDRI a Access Now, která se dlouhodobě a velmi intenzivně věnují problematice bezpečného internetu a umělé inteligence a nebezpečí sběru citlivých dat. Bylo mi ctí a potěšením s nimi spolupracovat na několika dokumentech Evropského parlamentu spojených s těmito závažnými tématy. Pozvání přijala i největší evropská odborová centrála ETUC, jmenovitě Isabel Sherman, která promluví o právech zaměstnanců a AI. O právech spotřebitelů a AI promluví zástupce organizace k tématu nejzasvěcenější, tedy Evropské organizace spotřebitelů BEUC. Děkuji vám všem, že jste přijali naše pozvání a podělíte se s námi o vaše vědomosti a zkušenosti. Setkáváme se dnes samozřejmě virtuálně, jelikož nás všechny zasáhla pandemie, kterou předvídal málokdo, a my jsme teď nuceni nepřipraveně reagovat na mimořádně komplexní situaci. To se bohužel v životě a v politice stává často. Popravdě až příliš často. Domnívám se však, že učinit tuto chybu i u umělé inteligence by bylo naprostým selháním nedozírných důsledků. Pronikání systému umělé inteligence do výroby, služeb a všech odvětví hospodářství je nedílnou součástí průmyslové revoluce 4.0, která bude mít zásadní a širokosáhlé dopady. V konečném důsledku se nebude jednat jenom o změnu technologickou, ale o komplexní proměnu kyberneticko-fyzicko-sociální. Rozvoj umělé inteligence bude mít dopad na celou společnost a na všechny součásti našich životů. Přitom už v tuto chvíli se nabízí úvaha, že jsme v rámci této debaty zaspali. Výkřiky o tom, že Evropská unie musí získat vedoucí postavení ve světě v oblasti digitálních inovací, to nedoženeme. A měli bychom si primárně uvědomit, že by to nemělo být za všech okolností naším cílem. Ano, i já si samozřejmě přeji, aby evropští zaměstnanci měli důstojná pracovní místa v oblasti digitálních inovací, export vzkvétal a evropské společnosti by platily v EU svůj spravedlivý díl na daních, ale pokud inovace ohrožují naše základní práva, musíme se jasně postavit na ochranu těchto práv a neřešit finanční stránku věci. Věřím tedy, že bychom se měli snažit vést debatu spíš o tom, že EU by měla získat vedoucí postavení ve světě v oblasti důvěryhodných a bezpečných inovací, orientovaných na člověka a kvalitu jeho života. Důvěryhodná AI však v EU nebude, pokud nedojde ke stanovení jasných a regulačních omezení pro způsoby využívání umělé inteligence a neakceptování využívání AI, které ze své podstaty oslabuje základní práva. Domnívám se, že je nutné, aby se v Evropské unii vyvíjely, zaváděly a používaly systémy umělé inteligence pouze pokud dodržují etické zásady týkající se respektování lidské autonomie, předcházení újmám, spravedlnosti a vysvětlitelnosti. Je nutné zajistit bezpečnost, inkluzivní povahu, přístupnost a spravedlnost všech výrobků a služeb vycházejících z umělé inteligence, zejména pro skupiny ve zranitelných situacích. Jinak se díváme na další dělící linii v již tak velmi rozdělené společnosti. A je mým osobním přesvědčením, že hlavním cílem umělé inteligence by mělo být zajištění ekologičtější a účinnější alternativy ke stávající technologii. Umělá inteligence a lidé by měli spolupracovat na plnění dlouhodobých cílů lidstva. Vytvořit rovnou společnost založenou na nezadatelnosti lidských práv, zejména práva na lidskou důstojnost, a zároveň dosáhnout rovnováhy s přírodou. Nejvyspělejší umělá inteligence není cílem sama pro sebe, což je, věřím, něco, na čem se dnes všichni shodneme a co naše politická skupina The Left prosazuje na všech výborech Evropského parlamentu. Nyní bych mohla mluvit o nedávném úniku informací z Evropské komise o AI, dopisu 62 NGOs schválené zprávě výboru IMCO o přípravě digitální budoucnosti Evropy, ale předám již slovo povolanějším expertům. V tuto chvíli vám již popřeji zajímavou a inspirativní hodinu, po které přijde řada i na vaše dotazy. Ty prosím klidně pište do chatu a nejlépe rovnou inzerujte, koho přesně se chcete dotázat. Ještě jednou díky, že jste tu s námi a předávám teď slovo Sarah Chandra z EDRI, která nás uvede do zásadního tématu umělá inteligence a základní práva. Prosím, Sarah, máš slovo.
Thank you very much for the introduction and for the invitation to this webinar today. As was said, this is a very crucial week for artificial intelligence regulation in the EU, so we're really happy that you have invited us to speak, but also to discuss this very important topic that we think really needs to have more attention in the EU regulatory space. So thank you for holding this space today. My name is Sarah Chanda and I represent European digital rights. I will just share my screen so you can see my presentation. European Digital Rights is a network of 44 digital rights organizations working across Europe. Today in my presentation, I'll use my 15 minutes to cover just a few topics. So firstly, why are we speaking about red lines or regulatory limits on certain uses or certain impermissible uses of AI? I will use the time to only focus on two particular uses, predictive policing and uses of AI in migration control or at the border. But note that other speakers will pick up on some other red lines that have been highlighted. And then I will also talk about AI in a broader political, social, and economic context in society, and note that how the fight for digital rights and human rights in the context of AI extends much broader into various different political arenas too, and that we need to take note of this context. Before I jump in, just a little bit of background about EDRI's work. We separate our core work into three areas. Looking at contesting arbitrary state surveillance is one. So the development of mass databases, biometric databases, the issues of our right to privacy and data protection, but also challenging big tech and platforms. And then broadly, the issue of technology of oppression, automated decision-making and artificial intelligence, and the context of biometric mass surveillance. I think my presentation today will touch upon both state for AI red lines and in what context does this policy argument sit in. So going all the way back to the February 2020 European Commission white paper on AI in the public sector, we noticed that there were several policy goals ongoing in that document. So one of those policy goals was the promotion of AI uptake in the public sector. We saw that the European Commission was pushing for in many areas of the public interest, there to be a rapid deployment of products and services that rely on AI and in their activities. This was, I think, a particular interesting area for us because this essentially advocated for the generalized promotion of uptake of AI, regardless potentially of the impact. This raised, particularly in the public sector, where we know that this touches on various specific and essential services, all the way from healthcare to transport to policing, migration control, and various different other areas, the allocation of welfare, for example. These are some of the areas that touch on not just the democratic process but also the extent to which AI and other different decision-making is touching on our daily lives and our access to services. When we were talking about the promotion of AI and uptake in the public sector, we also were very concerned about what about the context of discrimination and the surveillance that is coming from the state. If we are advocating for the promotion of AI, are we also advocating for more technologies that discriminate and surveil us? This was a very big question that civil society had in its mind. Also, we saw in the AI white paper that there was a recognition that fundamental rights come into play here. However, that should be balanced with other policy goals. And the promotion of AI uptake was one of those policy goals that fundamental rights should be balanced with. We thought that this was developing what would be potentially quite a problematic policy discourse, which was essentially seeking to put innovation in contrast with fundamental rights, and to say that more and more as civil society call for limits on the uses of AI and fundamental rights safeguards, that this could potentially limit innovation. We think that this is a really false binary that is popping up in the AI debate that seems to put AI innovation somehow in contest with fundamental rights safeguards and AI limits. Completely to the contrary, many digital rights and human rights organizations are arguing that innovation instead should be defined by the extent to which technologies are in compliance with fundamental rights. And we really believe that we should avoid this false binary between innovation and fundamental rights protections. We also saw that tech companies and industry were really also very prominent in this debate, calling for the EU not to draw red lines around uses of AI for the fear that this would overregulate and halt innovation. To the contrary, civil society have been very strong in their call, and you'll see in the bottom left corner a link to our coordinated civil society call, where 62 organizations had sent a letter to the European Commission to call for red lines on applications of AI that violate or threaten fundamental rights. And so we'll talk about that a little bit more today. So what do we mean by red lines, and why would we call for that? In particular, we're calling for certain regulatory limits, and in many cases prohibition on certain uses of technology rather than the technologies themselves. Here, very important is both the context and the purpose for in which that these technologies are being deployed. Why are they being deployed, and what will be the implication on fundamental rights? This is what we are looking at. Why are we calling for red lines? In essence, part of this is the need to set a regulatory framework that is underpinned by fundamental rights, and that does not create a fiction to say that any use of technology is legal and is compliant with fundamental rights. This is incredibly not true, and also perpetuates what we were talking about earlier, which is this harmful idea that innovation in itself is beneficial, despite the impact on people and despite the impact on communities. We also call for red lines in order to attempt to reverse the burden of proof. So currently, in many harmful uses of AI that we will talk about some examples a little bit later, there is a huge burden on civil society and also communities affected to prove how these uses threaten human rights. Number one, this is very hard because of the transparency issue. We often, particularly in the public sector, know very little about how such uses are being deployed, particularly by public authorities. Sometimes they're in the testing phase, sometimes they're in full deployment phase, and we know very little about when they're being deployed and also how to measure the impact. But we also have very many administrative and procedural barriers in order to challenge them effectively in the courts. Putting a red line or a generalized prohibition on certain uses helps us to reverse this burden of proof, because it requires not just the companies developing, but also the public authorities that are hoping to use certain deployments of AI, that they will have to prove that they do not violate the law, as set out by the AI regulation that will come into force once this process is ongoing, but also other laws such as non-discrimination law and data protection law. They will have the burden to prove that such uses are in compliance with those laws, rather than putting the burden on civil society and community affected. Here is again a link to the civil society letter which called for AI red lines. One of the uses I would like to talk about is predictive policing. This was one of the red lines the civil society called for. Predictive policing is, in essence, the use of a system to forecast or predict where crime is likely to happen or by whom. So there are two types, and we will see examples of predictive policing systems, which are, in essence, crime mapping systems. And also predictive policing systems would take the form of databases which look to formulate a list of high-risk individuals who run the risk of potentially committing certain crimes. There's been in-depth research into how such technologies exacerbate systemic racism and discrimination, particularly against certain communities. Not only in terms of the underlying problems with the data that is used, particularly in that the data used to make these predictions doesn't necessarily reflect to actual crime and actual harm in question, but rather reflects patterns of policing and where the police are already very present. But also a very much broader concern that such predictive policing systems are already very targeted at certain crimes and in certain types of unacceptable behavior. So often predictive policing systems are very much targeted at low impact crimes that are more associated with racialized and poor communities, as opposed to, for example, white collar crimes and tax related crimes. So already there's an inherent aspect of systemic discrimination and inequality when we look at what crimes and what types of behavior such systems already target. There's also a very big concern about the democracy of this type of system. Who gets to participate in conversations about such interventions? Often we know very little about when a predictive policing system is going to be deployed by a particular police force, and the communities that are very likely to be targeted and data is processed about them have very few opportunities to even know about such use, but also to opt out of being subject to such systems. There's also a very big concern about the overreach of the private sector with respect to public functions such as policing. So often predictive policing systems are developed by private companies. Due to their lack of transparency, their opacity, and also their complexity, often many researchers have raised the problem that many public authorities, when they're using such systems, don't really fully understand them. They don't really fully understand the predictions that they generate and have a hard time challenging them, therefore presenting a risk of automation bias and the idea that the less likelihood of police officers to challenge the predictions that such systems have made. Then also from the issue of the individual, many predictive policing systems do not operate in the system of what crime has already happened and how to respond to it, but this idea of prediction, the pre-crime area, what people will do in the future, really harmful for the presumption of innocence, and also the idea that we should have committed a behavior before we are experiencing the consequence of it. And so this pre-crime area raises some really problematic ideas for this presumption of innocence, and the idea that our behavior should not be mapped and predicted by public services. I will really quickly give some examples from the context of migration control and policing. So again, it's a very untransparent and opaque area, but we've seen, particularly at the EU level, a number of testing of AI systems, particularly unpiloted military drones at borders, and the Frontex and the European Coastal Agency has been engaged in this. Also, risk assessment systems throughout the immigration process. One key example came from the UK, where 7,000 students were wrongfully deported and put at risk at deportation because of an algorithm that decided that they were cheating on language acquisition tests. But we have also seen other uses of problematic AI in the migration process, such as the testing in the EU border control funded case, where we saw that proposed lie detection technology based on very flawed science, using facial recognition technology, was being used tested on migrants in the course of the visa application process. So there are various different examples. We know that this poses a number of risks. In some contexts, we have to look at the wider migration control context, where there is also an increasing push towards the use and the gathering of biometric data from migrants in very precarious situations, but also as children, and an increasing push in the Migration Pact to lower the age on which biometric data can be taken from children. There's also the idea that testing on migrants poses some really huge risks. Why should migrants be the testing ground for innovation, for the development of AI technologies? Can there be proper consent in that situation of extreme power imbalance? And also, to what extent should the EU facilitate that profit-making enterprise? And the Frontex files, the extent to which Frontex met with private companies in order to develop biometric and other AI-based technologies is a very serious concern there that we need to be thinking about. This is a quote from EDRI's research by our researcher Petra Molnar, who is a Mozilla fellow at EDRI. She did a research into the human impact of the uses of AI at technology. And here is a quote from one of the interviewees, Caleb, who is originally from Ethiopia and is living in Brussels. He said that in the process of undergoing the migration process and the gathering of biometric data from him, he felt like a piece of meat without a life, just fingerprints and eye scans. When we're talking about such technologies, often we're really focused on the general human rights impact of these technologies and this question of innovation, this questions of law, but we also forget to think about what is the human impact? What does it feel like to go through that process? And is that fair? Some other AI red lines that we've highlighted that I believe some of the other speakers will pick up on are uses of biometric surveillance technologies in the public space, which I believe Daniel will talk about. We also highlighted a real concern with use of risk assessment tools in the criminal justice system and pretrial context, in particular, the use of algorithms to predict the risk of certain people likely to recidivate or commit crimes again, and the extent to which this impacts their fair trial rights and their access to proper sentencing procedures, particularly considering the huge research in the US in particular into how such processes are very likely to discriminate, particularly on racial grounds. We saw in the AI leak that there was a consideration of social scoring. However, we are very much considering to what extent this took the full extent of the social scoring that is happening across Europe already. So increasingly the use of AI systems to determine access to social rights and benefits, including various forms of algorithmic worker management, student surveillance, and uses of AI to determine access to welfare and social security. One particular example that maybe all of you have heard of is the risk assessment welfare risk system put forward in the Netherlands, which disproportionately marked people of color and working class people as likely to present a risk of fraud in the access to their welfare payments. Daniel later will talk a little bit about reclaim mass surveillance, but I just wanted to point to the fact that EDRI is coordinating the Reclaim Your Face campaign, which is calling for a full ban on facial recognition and other biometric technologies as deployed in the public space. This campaign, which you can reach at this website, reclaimyourface.eu, is engaged with 60 organizations calling for this ban, and currently we're at 47,000 signatures and calling for a ban on our way to 1 million signatures in our European Citizens Initiative petition. And then very quickly before I end, when we're talking about the regulation of AI, we are talking about certain uses of technologies, but we think there's a broader context that we need to really take into account, in particular, not just the certain uses of technologies, but the broader ecosystems of surveillance that the EU is increasingly engaged with. And that AI really only has this large impact in that broader context of the ecosystems of surveillance. So we see references to AI in the Migration Pact with respect to the Eurodac proposal and the proposed expansion of the Eurodac database, but also with respect to the Europol regulation and the idea that operational data should be used to train AI and to expand the remit of the Europol regulation. Both, I think, pose some of the same risks that I've already talked about, which is that extending existing forms of police or migration control discrimination and surveillance. And this is part of the broader infrastructure through which the regulation of AI really already sits in. There's also a broad question of democratic oversight. So not only do we need to know how such technologies work and how they operate and how they come to their predictions, but also what is the process by which citizens and people that are affected by their technologies get to decide whether or whether not such technologies are allowed to be deployed, particularly to the extent that they affect their access to services and they affect and make decisions that impact their lives. This is really a big question that I do not think has really taken the space that is needed at the EU level when we're talking about the AI regulation. There's also really concern about questions around bias or structural discrimination. Many of the uses that I've talked about today, sometimes they will counter in our argument that, well, if we dismantle the bias, if we take away the bias from the underlying data sets, then these technologies will be okay and the harms that you've talked about will not happen. Often such technologies use data that is reflecting a reality, which is a reality of structural discrimination. We really want to seek to move away from this obscuring argument that bias can be somehow removed with a few technical tweaks. And actually, often such technologies cannot be prevented from exacerbating an existing discrimination that exists in society. And in fact, regardless of the technical tweaks applied, they are likely to exacerbate these forms of discrimination. There's also, I've talked about privatization, so I won't repeat myself, but there's also a concern about whether the high-risk category in the AI leak will actually address some of the harms I've talked about today. I think this can be a conversation we can pick up another time, but often from what we've seen in the AI leak, this category of high risk has placed many of these uses of AI in them. However, what are the actual requirements that fall from the categorization of high risk? If most of the burden and most of the requirements fall on providers, so the developers of AI, the people that make profit from them themselves, to make the necessary changes, but also to self-assess their own compliance, then it might be that this high-risk category is not as strong as it sounds. I will leave you with a couple of recommendations of where do we go from here. Particularly for people working in the European Parliament, I think that there's a really strong role to play to ensure that there is a robust coverage of red lines in the AI regulation, and that they go much further than what was contained in the AI leak, to include some of the uses that our speakers will talk about today. Also to think about how we create an inclusive process about how do we decide those red lines. So far we have seen that the Commission has proposed them. How do affected communities, how does civil society engage in that process? How can we have more opportunities like this where from across the Parliament, we get to discuss with people that are probably the most likely to be affected by these uses of AI, how we set those red lines? How can that be a democratic and inclusive process? Then I think there are many other concerns that we won't have time to talk about today, but how do we ensure that the fundamental rights governance is as strong as possible? So speaking about the requirements, speaking about the process to determine what is high risk, speaking about the recommendations on discrimination and bias, and how we can strengthen them in any ways that we can. And lastly, to go back to reclaim your face, I think that there are many other ways as opposed other than regulation that we can make our voices heard, and the European Citizens Initiative calling for the ban on facial recognition and other biometric technologies in public places is one of them. So we would really encourage you to engage with the campaign where you can. And with that, I will leave you. I will stop sharing my screen, and thank you very much.
Thank you, Sarah. You can. I want to ask you in the beginning that you can change the languages at the bottom on the screen. At least I have it at the bottom on the screen. Yeah, that means that in the down you can choose your language. There is the interpretation for languages. That means that because you ask us in a chat, and I want to only say you how is it and that this is possible. But now, thank you, Sarah, for your great introduction to the problematic. I believe that we have a note. Some possibilities. How important topic is it for us? And the AI I will speak Czech, sorry. Dopady umělé inteligence na základní práva jsou skutečně dalekosáhlé a nesmí být podceňovány. Stejně tak podstatnou otázkou je i to, které u AI garantovat vysokou úroveň ochrany spotřebitelů, o čemž nyní promluví David, kterého už vidíte. A já ho tady vítám mezi námi. A David je z Evropské organizace BEUC, za kterou spolupracujeme, a já mu moc děkuju, že je tady dnes s náma, protože je expert a vede tým specializující se na digitální práva. A Davide, máš slovo, moc se těším na tvou přednášku a moc děkuju BEUCu za veškerou podporu, kterou nám při pojednávání těchto dokumentů poskytuje v Evropském parlamentu. Velmi si ji vážíme, je pro nás důležitá.
Thank you very much. Sorry, I'm hearing myself quite okay now. Thank you. It was a bit strange to start with. So thank you very much for the invitation. I'm really happy to be here. Indeed, my name is David Martin. I'm the team leader for digital policy at BEUC, the European Consumer Organization. For those who don't know us, BEUC gathers 45 independent consumer organizations from 32 countries from all across Europe. And AI is an issue we have been working on for some time, and it's one of our main priorities. And it's without falling into hypes, because we agree that there's a lot of hype around AI and what it can or cannot do and the benefits that it can bring or not. I think we can safely say that this technology is set to change a lot of things in our society, in our daily lives, both as citizens and as consumers. And we want to make sure that we reap all the benefits and that we minimize as much as possible all the risks and challenges that the technology brings. So from our perspective at BEO, we are focusing on the issues related to consumer protection and how consumers interact and will interact with products and services that are powered by artificial intelligence. And as I said, there's a lot of potential that the AI will power innovative services, better services, will help our lives, daily lives, but there's also a lot of risks related to fundamental rights, as Sarah was mentioning, and beyond. And I also wanted to mention here that consumer protection is often forgotten, but consumer protection is also mentioned in the Charter of Fundamental Rights in Article 32, that the EU policy should strive for a high level of consumer protection. So this is important to keep in mind. Now we need to make sure that consumers have strong rights and that they're protected, and that legislation and the legal framework that regulates AI is up to the challenges. So we carried out a survey last year. 8 of our members from 9 countries carried out a survey about consumer perceptions about AI to see what they were worried about and what they think about the existing regulatory framework. And the results are quite clear. So a majority of the respondents said that they see potential, that AI can help them, for example, in areas such as predicting financial problems or traffic issues, mobility around cities, and also predicting health issues. But they also expressed a lot of concerns, for example, with regards to AI leading to an increase of abuse of their privacy, AI being used to manipulate them and influence their decisions, AI leading to more discrimination. So there's all these issues that are already in consumers' minds about the technology. They also, the respondents indicated that current legislation doesn't seem adequate to deal with all these challenges. They didn't feel that they were protected adequately, and also this pointed at the powers of the authorities that are there to protect them, that they felt they didn't have the powers that they needed to address all the challenges that the technology creates. So I wanted to talk about a little bit what we need in terms of legislation to ensure adequate consumer protection. Mostly, so I'll be talking about the upcoming, what we expect or we would like to see in the upcoming regulation, about the red lines, about consumer rights, enforcement infrastructure, but also more widely beyond the upcoming legislation, there's also other pieces of the puzzle that will be necessary to ensure there's an adequate legal framework to deal with all these problems that we are talking about. So starting with the upcoming regulation, I think that tomorrow is a big day for a lot of people. We have been patiently waiting for this since Mrs. von der Leyen announced it was coming when she took office. It has taken a little bit more than 100 days, but it seems that it's here finally. So we will see what comes tomorrow. We got a few indications based on the leak, but yeah, we have to take the leak with some caveats, because apparently it's from a few months. It's a few months old, so we don't know exactly what will be there in the end. But basically, from our perspective, there are a few elements that are fundamental. In terms of the legal framework, this regulation should set the foundations, basically, on a horizontal level, about a certain principles and basic rules that should apply to all AI applications across the board. So for us, it should be really more than just about high risk applications. And until now, the focus has really been on high risk applications. The red lines, of course, shouldn't be only about high risk applications. So this is already a good thing that we could say that the league at least was promising from this regard in terms of establishing some red lines. But if we looked at the text, it really, the focus was still mostly on high risk applications. And from our perspective, consumers should be protected and should have strong rights and be able to trust any application or any product or service that is powered by artificial intelligence, be it high risk, low risk, medium risk. So it really, there's the necessity to set at least some basic principles and rules for everything, which relate to transparency, which relate to fairness, which relate to security, to robustness. Now, all those might should, all those principles which apply across the board, and also the red lines for sure should apply across the board. We can then have a more gradual approach depending on the level of risk that a certain application poses. There should be different obligations and requirements. I'm not saying that low risk and high risk applications should have exactly the same obligations, for example, in terms of ex-ante assessments for conformity, or in terms of how documentation obligations and certain obligations towards the authority to make sure that all the rules are respected. But this gradual approach is, let's say, the second step. The first step is getting the fundamentals right for everything. So these principles and coming to the red lines are key, and they should be the basis for the regulation. There are certain things that simply should not be allowed, and Sarah mentioned in her presentation already quite a few. I will pick up on the issue about using the characteristics or certain characteristics of people to influence their decisions, to manipulate their behavior, to exploit their vulnerabilities. From our perspective, all these should be part of the red lines, because AI actually is increasing the imbalance, let's say, that we see in the digital area. So it's really increasing what we're calling the digital asymmetry. So the black box phenomenon, where you don't know what's happening and you don't know why you are offered certain things, or why certain thing happens when you're using digital products and services. AI is really making things even more complex from a consumer perspective, and leaving consumers even more on a vulnerable situation. So where we get to a point like basically everyone is vulnerable. So we have to take all this into account and ensure that the biggest risks that the use of the technology can bring are basically controlled from the beginning, and certain things are simply not allowed. So for us, it's very important that this regulation sets those kind of red lines, and in addition to the general principles. And this also links to the reversal of the burden of proof, which Sarah also mentioned, which for us is also a very important element. It should be for those that develop and put in the market and use AI systems to demonstrate that these systems comply with the law, and to demonstrate that these red lines are not crossed. So that's really a fundamental point, because on the other side, we are really not in a position to be able to assess a lot of the times properly what's going on, simply because of the lack of transparency, for the lack of resources, for the transparency, resources, and the complexity of all these systems. So it's very important that the burden is on those that develop and use the AI systems. In terms of consumer rights, I wanted to mention issues such as right to get a decision properly explained and be able to understand how things are happening and why things are happening, the right to be able to contest the decisions, right to be able to ensure that there's human oversight at certain situations, and also the right to redress and make sure that you have remedies if something goes wrong, to be able to correct the harm that has happened to you. These rights should complement rights that already exist in other pieces of legislation, which are important and will continue to be important. For example, the GDPR, and we need to make sure that they are properly enforced, but they also have their limitations. And here we are talking about a different scope. So it's not only about processing of personal data. So there might be situations where algorithms manage to work in a way that they are actually not, not processing your data directly. And you still want to make sure that that you have those rights to understand and contest those decisions that are taken that affect you directly. And lastly, in terms of the regulation, I wanted to mention the enforcement aspects. And here, as AI is a cross sectorial topic, let's say, it's going to touch upon different areas. It's going to be used all across the board in health services, financial services, you name it, many other, energy. So it's important to make sure that we have a system that ensures that those who are in charge of overseeing all those areas are talking to each other and they are sharing their knowledge and expertise. For us, that is key. It's also key to make sure that consumers know who to turn to in case they have a problem. And it's key to allocate responsibility for oversight clearly, so that we don't have a situation where one authority is sending the ball to another authority saying, no, this is an issue for data protection, this is not for us. This is an issue for consumer protection, not for us. So make sure that it's clear who has to take the lead and when, but make sure that they have to coordinate. And also ensure that there are no bottlenecks. So we had still have a lot of hope for the GDPR and the potential for achieving EU-wide enforcement when you have cross-border cases. But at the moment, we're seeing how certain issues are suffering from problems of enforcement bottlenecks, where a single authority is charged with a lot of very important cases, and things are not moving for different issues. So there has to be a mechanism there to make sure that this type of bottlenecks do not repeat. And also there needs to be an important element regarding private, what we call private enforcement, to make sure, for example, that NGOs can represent people who have been harmed by AI systems, and make sure, for example, that instruments like the collective redress instrument that was recently adopted in the EU are included in the scope of the regulation, so that consumers can benefit from that as well. All these issues are very important from our perspective. And I'll just stop one last point. It's about these other pieces of the puzzle, because the upcoming regulation is really, as I said, is the foundation, but it's not the only legal instrument that matters here. There are issues, for example, related to liability, which would have to be dealt with in the context of reviewing the product liability directive. There might be another liability instrument specifically focused on AI. We have to look at the consumer key as well to make sure that it's fit for purpose to address digital asymmetries I was mentioning before. There might be other sectorial legislation we need to look at in financial services or in health. So this is really just the beginning, let's say, of a wider and broader process. And I'll just stop here, and I'm looking forward to the discussion. Thank you.
Velmi děkuju, Davide, za tvůj příspěvek. Často jsem si do něho vzpomněla, kterak velmi často v debatách právě o AI v Evropském parlamentu zaznívají slova rovnováha v návaznosti na to, že musíme mít jasná pravidla avšak nesmíme přílišnými restrikcemi zničit šance evropských firm na trhu. S tímto přístupem samozřejmě lze částečně souhlasit, ovšem nikdy se to nesmí stát podle mého názoru na úkor ochrany evropských spotřebitelů, což si nejsem jistá, že rezonuje dostatečně. Minimálně ve výboru IMCO jsme s tím velmi bojovali, nějak se ten kompromis povedl, ale bylo to velmi silné téma. Chtěla bych vám všem teď připomenout, že dotazy na všechny řečníky můžete psát do chatu. Já se budu ptát za vás ve chvíli, kdy přijde čas. A ještě jednou děkuji Davidovi a předala bych slovo paní Isabel Sherman z největší evropské odborové centrály ETUC, která promluví o právech zaměstnanců a AI. Máš slovo, Isabel.
Katerina, thank you very much, and I hope you can hear me properly. Thank you for your invitation to take part in these discussions ahead of tomorrow's publication of an important document. I would like also to stress that it has been awaited since a while, and from the ETUC, from the European Trading Confederation side, we are very happy, if I may say, start with a positive note that it's going to be a legislative proposal. We understand the regulation, and I think this is one very big step ahead in the discussions we've been following since the ethical guidelines on artificial intelligence, where we understood that the whole dimension related to how to use artificial intelligence in relation to human beings, organizations of society, was located at the level of guidelines, so non-binding instruments, so to say. And this is for us key in that respect. This is also key for us in another respect. And I would start where my predecessors have stopped in terms of how do we understand innovation. And so far, it has the narrative around artificial intelligence, around innovation, is that, you know, we shouldn't do anything. We should just let innovation go, and with this kind of understanding and assumption that innovation is good for all, but innovation cannot stand any regulation. It looks like barrier. It looks like elements in the way of innovation that would stop the pace of innovations. And here I must say, we do not agree with these assumptions. We have seen that the lack of regulation is exactly what stops a good and robust and a sustainable innovation that would deliver for all society, and not for just a few. So I think we are very happy in that respect that we are looking into regulation to frame innovation so that innovation can deliver for all society, and in particular, because we understand that innovation might have, I would say, a dark side, and some of the interventions before me have clearly stated, and I will recall some of them, the issue of AI, looking into the issue of privacy, looking into the issue of undue surveillance, without feeling from the side of certain groups of society, without feeling the need for regulation in that respect. And this is something that is not in line with the precautionary principle, which is in core in the Treaty of the European Union. So I think here, to start with a positive note, we are looking forward a regulation. Now we have a leak, and having discussed with DG Connect recently, we understand that this leak is a very old one, and that we should not stick to that one in terms of what will come tomorrow. And this is where, still discussing on this issue with DG Connect, we fear some of the loopholes that have been identified so far will not be clause or will not be resolved with the regulation. And I would like also to recall a very important compass that the European Union should have when issuing regulation in general is the Charter of Fundamental Rights of the European Union. And if you recall the Article 51 of this Charter, it says that the provision of the Charter has to be taken on board by all institutions and bodies of the European Union. And it has also to be taken on board by the member state when the member states implement union law. And institutions and bodies of the European Union, as well as the member state, should therefore respect the rights and observe the principle and promote the applications of the Charter of Fundamental Rights. And I think this is where we understand that the regulation could deliver much more than what it does in terms of using the Charter of Fundamental Rights as a compass. And we understand that behind the innovation part of AI, there are risks directly to the people involved in artificial intelligence, from the developer, from the side of the developer up to the one who are impacted by AI, and in particular at the workplace, where I will locate, so to say, my intervention. So it is clear for us that any regulation coming from the European Commission on artificial intelligence should have as a compass the promotion, the respect and the promotion of fundamental rights when it comes to, and this is very key at the workplace, when it comes to the fundamentals of this charter, looking into decent workplace, looking into the dignity of human being, looking into the issue of decent working condition, looking into the issue of the respect of the protection of personal data, looking into the issue of non-discrimination, and it has been also mentioned earlier, looking into the issue of fair working condition, and finally looking into the issue of governance in terms of the involvement of trade unions and workers' representative when it comes to the introduction of AI at the workplace. So here, something which is for us key, and it is key exactly because we have identified, and it's not new, but it has been exacerbated by the pace taken by digitalization since the pandemic has started. The pace of artificial intelligence tool introduced at the workplace, and next to the issue of using algorithms to recruit or even to fire people at the workplace, we also have seen the dimension of home office and the related algorithm in the computers and laptops, looking into how to surveil oversight people outside their workplace when they have to do home office, for example, up to the tracking of people at the workplace to make sure that they respect the social distancing, and in particular around the issue of identifying potential contact cases in relation to the virus and in relation to the potential spread of the virus. So I think here what we've seen is that the test phase of such product have been done live at the workplace without information, without consultation of the workers' representative on the trade union, and without the consent of the workers. And I think this is something we cannot accept. This is not innovation, and this is not delivering for all. Taking for granted that innovation has always a positive side, I think is to be very naive or even misrespecting indeed the way European legislation should deliver for all. what is key for us, and I think this is the first red line, or the second after the respect of the Charter of Fundamental Rights as a compass. And I would end this first red line by saying an impact assessment is key, and an impact assessment cannot be reduced to a paragraph saying that the fundamental rights according to the Charter will be respected or will not be violated. I think we definitely need to have more when it comes to the impact assessment backing up a European legislation, that this assessment is much more complete in terms of what does that mean, what are the fundamental rights at stake, and how they are protected, how they are promoted. I think this is key for us also to be clear in that respect, and usually it isn't. The second is, of course, the second red line is, of course, that any innovation at the workplace and AI, including those innovation, should respect the principle of the human remains in control. And here we touch upon the issue of discrimination in terms of, for example, recruitment of workers at the workplace through algorithms. So the pre-selection of the shortlisting of application on the basis of algorithms that, of course, have been trained and organized in a way to organize a selection. And the criteria for those selections are, of course, including some bias when it comes to, for example, the gender, when it comes to where you come from, or and what kind of names, for example, you have. So I think here it is key for us that we cannot accept that the decision is taken by a machine and on the basis of algorithm that organizes selection. And this selection is, of course, created by the developer and created by the operators. So I think here, coming back to later to the issue of liability, I think we have to be very clear that leaving the liability to a machine is also something we cannot accept when it comes to AI applications and AI tools at the workplace. Likewise, we have seen that algorithms are used to assess the performance at work and also to lead, according to the assessment of this performance, to a potential firing of workers through the algorithm without the intervention of a manager, for example, and this is also something which is not acceptable in our society. And this is the reasons why AI should be put in the category of high risk when it comes to this application in the workplace. Now, what we understand, and it has been also clearly said by Sarah, that what does mean high risk? It seems to be a safeguard, but we don't know really what is behind this safeguard. And what we understand is that at the workplace, AI will be considered as high risk when it comes to recruitment, especially to prevent non-discrimination. When it comes to evaluation at work, what does that mean? Is it in terms of the assessment of your performance? But here again, on the basis of what kind of criteria, what kind of algorithm, and also what does that mean in terms of, for example, the follow-up of this assessment in terms of promotion or in terms of termination of your work contract. So this is also the second red line, which is for us key, is that we cannot accept that machines take decisions, in particular at the workplace, independently, irrespectful of existing situations and existing structure that we have. And this is where I come to my third red lines, which is the governance dimension. I think we cannot accept that AI as a product, and we understand this is a product or a service, is developed without the involvement when it comes to the workplace of the trade unions and the workers' representative who should have access, this is an obligation, who should have access to this information and should be consulted before the introduction of such applications or tools at the workplace, because of their impact on the work organization, because of the impact on the working conditions. And this is something that we do not see. And we wonder how can be that the European Commission issue a regulation, of course, not under the lead of DG Employment, but should be in relation and in negotiations. The internal intersectoral services discussion should be there. How come that we do not have any reference to the existing acquis communautaire when it comes to the need for information and consultation of the trade unions and the workers' representative, which in principle should be mentioned. How come, for example, that the issue of the GDPR is just mentioned, but when questioning why not adapt it when it comes to AI, or we do not want to touch the GDPR? Of course not. A reference to the GDPR is okay, but it can be adapted to specific situation, and in particular when it comes to the issue of artificial intelligence. So for us, it is key that the workplace, and not just specific situation at the workplace, but the workplace as such is taken as a high risk when it comes to the adverse impact of artificial intelligence, in particular, when we have, for the moment, no information on the issue of liability. And it has been mentioned, the issue of liability will get raised later on by DG GROW in the framework of the revision of the Product Liability Directive. So here again, the issue of the liability of a product should be directly linked to the product itself. And when we regulate artificial intelligence, we should be well aware of this dimension. I think I would like to end with the role of the European Parliament. I think it is key. I think the European Parliament in this development, in this dossier, in these discussions we have on very societal development and direction to take, is a game changer. And this is where I would say that make the link with my last point in terms of the governance, the democratic governance at the workplace is linked with the democratic process at the European Parliament when it comes to such regulation impacting society as a whole, impacting society in specific cases, in particular at the workplace. The Charter of Fundamental Rights is the compass, the only compass that the Commission should have, and the other institution being the European Parliament, but also the Council when discussing the follow-up of the legal proposal of the Commission. We should look into very ambitious amendments in terms of securing that the people are at the center of artificial intelligence, that artificial intelligence is regulated in a way that it delivers for all and not just for a small group of society. And we have to make sure, and that will be my last point here, that what is left in terms of the technicalities and the details when it's to be regulated, that we do not leave too much space to the private norm setting, standardization. I think we have to understand that standardization can help, but not when it comes to ethical dimension, not when it comes to regulation of non-discrimination at the workplace, not when it comes to the issue of how to organize quality jobs in relation to artificial intelligence. And what about the issue of working conditions? I think here this is not to be regulated in the frame of standardization, but has to be regulated in the frame of public regulation. And I think here the European Parliament will have a big role to play with the support of the ETUC in any case. And I would like to reiterate that we have to make sure that we deliver, all of us, on the basis of the European value, that we deliver for the people of Europe and that we make sure that what we deliver make sure that technology is at the service of the people and not the other way around. And I will end with that, and I'm very much looking forward to the discussion.
Děkuji moc, Izabel. Izabel, jistě mi budeš věřit, že jako zástupkyni frakce The Left v Evropském parlamentu mi bylo skutečným potěšením slyšet to, co jsi řekla, a názor odborů na problematiku čtvrté průmyslové revoluce. Je ovšem jasné, že toto téma musíme řešit ještě intenzivněji, protože bude znamenat i značnou společenskou proměnu. A mnohokrát ti tedy děkuju za vše, s čím s nás dneska seznámila, a těším se na spolupráci i v budoucnu. Bez pochyby našich velmi dobrých vztahů využijeme. Posledním panelistou dnešní konference není nikdo jiný než Daniel Laufer z Access Now. Pokud někdo nějakou nevysvětlitelnou záhadou jeho práci neznáte, pak po dnešním dnu jistě získáte silnou motivaci to napravit. Osobně velmi doporučuji, kromě jeho článku na webu Access Now, i jeho stránku immit.org. Nyní už mu však předám ráda slovo, aby vás více seznámil s svým pohledem a pohledem Evropské unie na AI a osvětlil nám, co přesně EU myslí tím, když říká, že artificial intelligence musí být etická. Danieli, díky, že jsi přijal naše pozvání a dávám ti slovo.
Great, thank you. So it's really a pleasure to be here and to be able to talk to you all today. I'd just like to open by saying thanks to the organizers of this, thanks to the Left, not only for organizing this event on a really key topic at a really key moment, but also for the recent support that Ms. Konechna mentioned on a number of initiatives that we took. And I'll also take the opportunity to use my bad Czech and say děkuji za pozvání. So a little bit of background first, maybe just on Access Now, because the topic that I've been asked to discuss is Europe's approach to ethical AI. So Access Now, for those of you who don't know, is a global human rights organization. We work across the world in many different regions and on a range of digital rights issues, including a campaign to document and combat internet shutdowns. And in our European office based in Brussels, we've done extensive work on data protection, including close following of the entire process leading up to the GDPR. Now, the way that we got involved in working on AI was that, whereas say in 2016, you constantly saw people talking about big data. That was the big buzzword. And then suddenly around 2017, everyone was talking about artificial intelligence, which, as all of you know, has a serious data protection component. So we recognized that this was an important development of our work. But what also really concerned us, and this comes back to the question I've been asked to discuss, was the big growth in people talking about ethics as a form of governance. And Isabel mentioned this as well, this concern that we had that suddenly we were hearing that ethical guidelines, ethical principles were going to be sufficient to govern and to combat the problems related to artificial intelligence. So we were already quite worried there. And just to give you a couple of statistics, there was a study in 2019 that looked at AI ethics principles, and they found 84 documents at that time. And 88% of those had been released since 2016. Algorithm Watch, a partner organization of ours, have also been documenting the publication of these principles, and they found over 200 at this point. And we asked ourselves, why are companies and governments so enthusiastic not only about AI, but about ethics as a form of governance? And the simple answer is we were critical of an ethics-based approach because ethical AI is a vague term. My background is actually in philosophy, and this was how I got involved in working with Access Now, because I was a philosopher who was critical of an ethics-based approach. because it's not enforceable. And there are many different ethical frameworks. Not all of them are in line with or even compatible with a fundamental rights-based approach, which is what we should be taking here in the European Union. Notably, a lot of the principles that are coming out of Silicon Valley are very utilitarian in their approach. And I'll come back to this at a few points later, because that approach where you're just looking at net benefit and you're allowing certain harms as long as the benefit is overall good is very much in contradistinction to a fundamental rights-based approach, and we need to really watch out for that. So Access Now, along with Amnesty International and some other civil society organizations, published one of the first documents to take a human rights lens to the problem of machine learning. That was the Toronto Declaration on protecting the rights to equality and non-discrimination in machine learning systems. That was published in 2018. Our Europe Policy Director, Fanny Hidvegi, was also a member of the Commission's high-level expert group on artificial intelligence. And we had a constant critical engagement there to ensure not only that the ethics guidelines themselves were as grounded in fundamental rights as possible, but to be sure that that wasn't being put as the ceiling, that we were going to take this next step towards regulation, because that's what we believe was really necessary to protect fundamental rights. One thing that's been brought up as well, Sarah brought it up, was that we were quite critical of the pillars of the Commission's approach, especially this one on AI uptake. The idea that promoting AI uptake was a good in itself. It's like saying we should promote the adoption of heavy machinery in all aspects of society. In some aspects of, parts of society, that's of benefit. In others, it would cause a huge amount of harm. AI is not a unified technology, and there are some aspects of it that we can and should pursue. They can be of great benefit to us. And there are other ones that we shouldn't. As Isabel mentioned as well, not all innovation is good. We can certainly keep up with the US and China in the use of computer vision systems for medical scans, but we should not compete with them in the use of facial recognition for mass surveillance. A final thing I'd want to say in terms of background was that we were quite worried when we saw with the publication of the Commission's white paper that the intention was to take a risk-based approach to the regulation. And our main worry there, and I think we've seen it kind of come out a bit in the leak, was that a risk-based approach often comes from the perspective that there are risks, but if we put in adequate safeguards and technical improvements, those risks can be mitigated and the technology can be used. But with artificial intelligence, and this comes back to the topic of red lines, we believe that there are certain uses which are simply impermissible. There's no amount of risk mitigation or safeguards that can make them compatible with the values that the European Union is founded upon. So we're very happy to see the inclusion of prohibitions in the leaked draft from last week, although, like the other panelists, we're worried that the carve-outs and the caveats are too great and actually, in the worst case, provide a legal basis for the use of these systems in certain circumstances. So just to then say, okay, if not a risk-based approach, what does it mean to take a rights-based approach? And I think that means, first of all, saying that there are certain violations or infringements of fundamental rights which are not permissible. Also saying that, as some of the other panelists have mentioned, fundamental rights can't be traded off against innovation or economic performance. There are certain cases in which we need to consider trade-offs, but that's among rights, not against innovation or other ideas. So we really need to have that lens. And when we come to talking about red lines, Sarah's already said a lot of great stuff on that, and I fully support all of the points she'd made, and I'll just make a couple of additions. One is that if a system currently suffers from technical shortcomings that could be remedied, then there's a consideration that we could have a moratorium, so a temporary ban until those things are fixed. I would point out as well that systems that work poorly tend to work poorly on already marginalized communities. And it's unacceptable to write that off as just a hiccup or a minor fault. If a system fails one group and works for others, it is discriminatory and should be under a moratorium until those shortcomings are fixed. But there are other systems that may have tech issues at present, have problems with accuracy, for example, but that even if they work perfectly, would still be incompatible with the enjoyment of our rights. And it's in these situations that we really need a ban. And Sarah has talked about some of those around predictive policing, use of AI surveillance systems at the border. But what I'd like to focus on here are, a group of technologies that we could call biometric recognition technologies. Now, I use the term biometric recognition because I want to be broader than just facial recognition, which is what most people are aware of. And these are applications of AI that either identify, single out, or classify people based on their biometric data. That could be your face, your ear, the vein pattern in your hands, or even the way you walk, your gait. And much excellent work has been done to show that how these applications have problems with accuracy. They've been shown, for example, to work be less accurate on women than men, and worse on people with darker skin, and therefore worst of all on darker skinned women. And this is a serious issue, and systems should not be deployed that perform poorly on certain groups, especially those that already face discrimination. But fixing the accuracy problem of biometric recognition technologies will not in many cases make them compatible with fundamental rights. And if we look, we can look at a couple of examples. So most discussion of the danger of facial recognition, for example, focuses on how it can identify people. So this is the application that we could call one-to-many matching, where you have a database or a list of suspects or wanted people, and then you're monitoring, say, a public space, a park, or a town square to see if the people who are being picked up on the camera match the watch list. Now, the use of facial recognition like this in publicly accessible spaces gives authorities, police departments, for example, the ability to track people wherever they go, and will lead to mass surveillance. And Sarah already mentioned the campaign, which Access Now is a member of, Reclaim Your Face, to call for a ban on biometric mass surveillance. And just to point to a recent example, we've seen this used in Moscow recently, where people who attended protests in the past were suddenly arrested and detained in the run-up to new planned protests. So they had been identified and then picked up before they even had the opportunity to attend a new protest with no intervention from the police beforehand. So the power that this gives police, and not only power, but incentive to criminalize people for exercising basic freedoms, means that we can't have this. We can't install these infrastructures because public money goes towards putting them in, and once they're there, the incentives are there to use them. We need to really have red lines now to stop these cameras and systems being installed. And again, just to underline that the argument is that these systems are bad when they don't work well, but awful when they work perfectly. There's no improvements or safeguards that can mitigate the harm to rights. Now, I see that we're actually coming short on time, so I'll wrap up relatively quickly, but there's another whole group of technologies. What I talked about now focused on where you're identified by a system, but there's other types of biometric classification systems where you're grouped into certain groupings. One example I can give you is gender, where your gender is determined by the bone structure of your face. These systems have been shown to systematically discriminate against transgender people and non-binary people. They could be used, for example, to control access to public bathrooms that would deny people access to basic services. We've also seen emotion detection systems, and this comes back again to the labor context, where they're used in interviews for jobs, and they're making inferences about the way you move your face or your body to say whether you would be suitable for a job. And it's really important to underline that there's no solid scientific basis for this. This is not innovation. This is actually taking outdated science, or pseudoscience, physiognomy from the early, late 19th century, early 20th century, and, dressing it up in fancy new clothes. But actually this type of approach, where we're determining people's life chances, we're making serious inferences about people based on physical characteristics of their face, for example, is exactly what fundamental rights were brought in to prevent. This is, World War II Nazi race science and being dressed up in machine learning clothes, and we're told that it's innovative. It's not. we've actually seen, and I'm not being speculative here, a paper came out last year that claimed to predict whether someone was likely to be a criminal in the future based on the bone structure of their face. So nothing about even their previous activities, which, as Sarah pointed out, is problematic, but just on the structure of your face. So we really need to ensure that there's proper red lines, there's real restrictions to stop systems being used like this. The European Union has to take an approach that is founded on fundamental rights forward with AI, and that will mean not pursuing and prohibiting certain applications like these. So I see that we're quite low on time here, so I'll stop, but I look forward to any questions we have time to discuss.
OK, mnohokrát děkujeme. Danieli, pracovala jsem již na problematice etické AI na 2 výborech a v Evropském parlamentu, ale i tak jsem se dověděla mnoho nového, musím říct. Sice to nebylo úplně povzbudivé, ale na to jsme od Evropské komise zvyklí a mělo by nás to pouze nabudit k intenzivnější práci. Jelikož mají někteří problém s překladem, budu dávat otázky teď anglicky. Unfortunately, we don't have time for many questions, but what was on my mind the most during this conference is this. We talk a lot about the leak from last week. We agreed it's a couple of months old and therefore we don't know how up to date it is. Please tell us very quickly, what do you consider the most problematic aspect in view of your organization? Thanks for your answer.
Who starts? I can start quickly.
Who wants?
Okay.
But shortly, please, because we are
Yes, one line. Article 4 about the prohibited use is a very good news and very promising. We will have to see the final text, but that's certainly something good. The rest, not so good. Really worried about the limited scope and the focus almost exclusively on high risk. Questions as well about how high risk itself is defined as well. So problematic from both perspectives. So there's nothing beyond high risk, and even high risk itself seems quite limited. And also there are questions about what are the obligations for high risk, and a lot of self-assessment for companies. And problematic that is a lack of direct rights for people. The regulation doesn't establish directly or clearly rights for people. I would stop there.
Okay, thanks. Now maybe Sarah, as a woman here. I see you.
Yeah, I would also agree with all of the points David has made. Just to emphasize the point around the prohibitions, the language is very strong, and yet many of the uses that civil society called for were not included in Article 4. So even with this carve out for public security of the prohibitions that were included, many of the things we've talked about today. So Daniel's point about automated sensitive identity trait recognition, even some uses of biometric mass surveillance, predictive policing, and uses at the border, none of these were included in the prohibitions. Rather, they were categorized as high risk. And yeah, just to re-emphasize David's point, for the most uses of high risk, it looks like that they will be self-assessed for, the compliance will be self-assessed by companies. So that doesn't really seem like the appropriate response for uses that the Commission even deems high risk. I'll leave it there.
So thank you, Sarah. Now, Isabel, if I want to please you.
Yeah. For us, it's key that we look into. Not sure I have an echo. I hope it's fine with you. Yeah. Quickly, democracy at work. The introduction of artificial intelligence has to be taken at the workplace with the information, consultation, and participation of trade unions workers' representatives. We have to have a collective bargaining and collective agreement when it comes to the introduction of AI at the workplace. and we can't leave it to the self-assessment of employers. I think it is key that when we speak of an informed consent of the workers, this informed consent has to be backed up by the workers' representative on the trade unions, so that there is a stronger assessment of what does that mean for the workers. And this is here with the sake of the protection of the workers, and so that AI delivers also for them.
Thank you, Isabel. And last but not least, Daniel.
Yeah, so I mean, fully to back up everything that's just been said. And again, maybe to add one new thing, we're very concerned about the European Artificial Intelligence Board, and that it will actually impinge on the competencies of the European Data Protection Board. And we're also very unsure about this. I think it's in Article 50, where member states can choose which authority to be the supervisory authority. We think we need a harmonized approach there. And from our reading so far, it seems that this should be the responsibility of the data protection authorities and the data protection board. This is something we'll need to discuss, but it seems to be, if you look at the Data Governance Act as well, where there's an establishment of a data innovation board, kind of multiple attacks on the authority and the competencies of the data protection authorities and the EDPB. So we'd like to ensure that doesn't happen.
Thank you, Daniel. Chtěla bych ještě jednou moc poděkovat našim řečníkům, což byly Sarah Chander z EDRI, David Martin z BEUKu, Isabel Schemann z ETUKu a Daniel Laufer z Access Now. Děkuji všem také vám, kteří jste nás sledovali nebo nás sledovat budete ze záznamu. Doufám, že nám všem dnešní den seznámil nebo umožnil se lépe seznámit s problematikou AI a nabudil nás zároveň k tomu chtít o ní vědět prostě něco víc, protože je to téma budoucnosti. Kromě stránek a sociálních sítí dnes zastoupených organizací doporučuji kromě zmiňovaného www.ameets.org rovněž bezplatný online kurz Elements of AI, který by měl být vlastně k dispozici ve všech jazycích Evropské unie. Za The Left v Evropském parlamentu mohu pouze říct, že jsme vyslechli poznámky expertů velmi bedlivě a domnívám se, že v mnoha směrech odrážejí i obavy, které máme my jako zástupci The Left v Evropském parlamentu napříč všemi výbory, které na AI pracují. Dnešním dnem nám byl tedy inspirací k další práci a budu se moc těšit na spolupráci nejenom s řečníky, ale pokud samozřejmě máte jakékoliv dotazy na nás, jako na poslance i z řad široké veřejnosti, tak jsme otevřeni, jsme k dispozici a moc rádi s váma toto téma budeme i nadále komunikovat, protože je to opravdu téma, které minimálně do konce tohoto volebního období, tedy se stávajícími poslanci, prostě bude žít, protože se bude řešit na všech úrovních. Takže ještě jednou díky moc, že jste se zúčastnili a těším se někdy na viděnou, ať už při třeba méně oficiální konferenci nebo při nějaké další konferenci, kterou budeme bez pochyby organizovat. Děkuji všem, kteří jste byli dnes s námi.
Thank you. Bye.
Thank you. Bye-bye.
Thank you very much.